Religious Courts Introduction. You hear the term Sharia Council, and what immediately springs to mind? For many, it's a jarring image, fueled by sensationalist headlines and political rhetoric, a shadowy, parallel legal system imposing ancient, harsh punishments, operating in defiance of national law. It's a narrative of fear, of a creeping takeover, of a fundamental clash of civilizations happening right in our own backyards. But what if that entire picture, that visceral, gut-level reaction, is built on a foundation of profound misunderstanding? What if the reality of these councils in Western countries like the UK, Canada, or the United States is something far less threatening and far more mundane? Today, we're cutting through the noise. We're not here to judge or to preach. We're here to understand. And that understanding begins with dismantling the biggest myth of all. Let's be crystal clear from the outset. Sharia councils in Western nations are not criminal courts. They cannot sentence anyone to prison. They cannot order corporal punishment. They cannot handle cases of theft, assault, or murder. Any individual, Muslim or not, who commits a crime is subject to one authority and one authority only: the secular criminal justice system of the country they reside in. This isn't a matter of opinion, it's a matter of law. The idea that a religious body could somehow usurp the state's monopoly on criminal justice is a fantasy. So if they aren't dealing with crime, what on earth are they actually doing? The answer, for the most part, lies in the complex, emotional, and deeply personal realm of family law. Imagine a Muslim couple in London. They were married in a civil ceremony, recognized by UK law, and also in a religious ceremony, a kara, recognized by their faith and community. After several years, their marriage breaks down. They go to the state court and get a civil divorce. Legally, in the eyes of the United Kingdom, they are no longer married. But in the eyes of their religion, they are still bound by the. For the woman, in particular, this can create a significant spiritual and social problem. Without a religious divorce, she may be considered still married within her community and unable to remarry in a new religious ceremony. She is in what is often called a liminal state, divorced by the state but not by her faith. This is where a Sharia council comes in. It acts as a form of mediation or arbitration panel that the couple can approach. The primary service they offer is the issuance of a religious divorce, known as a khula for a man's initiation, or a siyah if initiated by the woman. These councils are essentially faith-based arbitrators, operating under the same legal principles that allow for all sorts of non-religious arbitration, from commercial disputes to labor disagreements. The key word, and the one that is so often ignored in panicked media reports, is consent. No one can be forced to go to a Sharia council. Their rulings are binding on the participants only to the extent that the participants have agreed to be bound by them. And even then, their decisions are always subordinate to national law. If a council's ruling on, for example, a financial settlement in a divorce were to contradict the ruling of a secular family court, the secular court's decision would always prevail. There is no contest. The state is sovereign. The councils also handle other communal matters. They might be asked to mediate inheritance disputes, ensuring that the distribution of an estate aligns with both Islamic principles and, crucially, the legal requirements of the country's probate laws. They might offer guidance on Islamic finance or business contracts, providing a service for those who wish for their affairs to be compliant with their faith. In essence, they are a community resource, a form of alternative dispute resolution, or ADR, that is culturally and religiously sensitive to the needs of its users. This isn't a radical or new idea. For centuries, various religious and cultural groups have maintained internal mechanisms for resolving disputes according to their shared values, all while living as citizens of a wider secular state. So why does Sharia in particular provoke such a unique level of fear? It stems from a confusion between the fiqh of Islamic jurisprudence, or in a pluralistic secular society, and the implementation of Sharia as state law in a handful of Muslim-majority countries. They are two vastly different things. The Sharia councils in the West are not trying to replicate the legal system of Saudi Arabia or Iran. They are providing a specific, limited, and voluntary service to a community within a democratic framework. Their power is not imposed. It is derived entirely from the voluntary consent of the people who walk through their doors, seeking guidance on personal, spiritual, and familiar matters that the secular state often has no interest or ability to address.
Jewish and canon law. Now, this model of a religious legal system operating for a specific community within a broader secular society is not unique to Islam. In fact, it has a much longer history in the West. Let's shift our focus to the Jewish community and an institution that has existed for millennia, the Beth Din, which literally translates to House of Judgment. Much like the Sharia councils, the modern Beth Din in a country like the United States or France is not a court in the sense that most people understand it. It holds no civil or criminal authority over the general population, or even over Jewish people who do not consent to its jurisdiction. Its role is to interpret and apply the collective body of Jewish religious laws to the lives of those who choose to live in accordance with them. One of its most significant functions, paralleling the work of Sharia councils, is in the area of marriage and divorce. In Jewish law, a civil divorce is not sufficient to end a religious marriage. For a couple to be considered divorced in the eyes of the Jewish faith, and for the woman to be able to remarry within the faith without complication, the husband must grant his wife a specific document called a deen. The Beth Din oversees this process. It ensures the document is drafted and delivered according to the strict requirements of deen, a process that has been refined over thousands of years. It's a deeply technical and ritualized procedure designed to ensure clarity and finality. Without a deen, a woman is considered an a chained woman, unable to move on with her life religiously. The Beth Din's role here is absolutely vital for the functioning of the religious community, providing a necessary service that the secular legal system is neither equipped nor designed to handle. But the Beth Din's purview extends beyond divorce. They are the authoritative body on religious conversions to Judaism, overseeing a rigorous process of study and commitment. They certify kosher food products, with their symbol on a package being a guarantee of adherence to Jewish dietary laws, or halacha. This is a massive industry, and the Beth Din acts as the ultimate regulatory body. Furthermore, particularly in more insular Orthodox communities, the Beth Din often functions as a court of arbitration for business and civil disputes. If two business owners have a disagreement, they might voluntarily agree to take their case to a Beth Din rather than a secular court. They do this because they trust the rabbinic judges, or hacharayim, to understand their shared ethical framework and to render a judgment based on principles of Jewish law regarding commerce and justice. Again, this is a form of binding arbitration. Their decision is enforceable in secular court, not because it's a religious ruling, but because it's an arbitration award the parties freely consented to. Now, let's turn to the largest single religious denomination on the planet, the Catholic Church. It operates arguably the oldest continuously functioning legal system in the Western world, canon law. This is a fully codified system of laws and legal principles made and enforced by the hierarchical authorities of the Church to govern its external organization and to order and direct the activities of Catholics toward the mission of the Church. It's not just a set of suggestions, it's a detailed legal code, the most recent version of which, the Code of Canon Law, was promulgated in 1983. So what do its courts, known as ecclesiastical tribunals, actually do? You've probably heard of them in one specific context, marriage annulments. This is their most public-facing function. In the eyes of the Catholic Church, a sacramental marriage is a lifelong covenant that cannot be dissolved by a human institution, including a civil divorce. A divorce ends the contract of marriage, but not the bond. An annulment, or more properly, a declaration of nullity, is not a Catholic divorce. Rather, it's a ruling by a church tribunal that, due to a specific impediment or defective consent existing at the time of the wedding, a valid sacramental marriage never actually existed in the first place. The process is a formal judicial proceeding. It involves petitions, witness testimony, psychological expert opinions, and a panel of judges, often including both clergy and lay experts in canon law. It is a meticulous and often lengthy investigation into the circumstances of the marriage. Beyond annulments, canon law governs a vast array of internal church matters. It dictates the rights and obligations of the clergy and the laity. It sets out the procedures for administering the sacraments. It governs the management of church property, finances, and institutions like schools and hospitals. It also has a penal dimension, but it's crucial to understand what that means. The punishments are spiritual and ecclesiastical in nature. A cleric found guilty of a canonical crime could be suspended from ministry, removed from their position, or, in the most extreme cases, laicized, returned to the lay state. These are internal disciplinary measures. A priest who commits a civil crime, like fraud or abuse, is subject to both the church's internal justice system and the full force of the secular criminal justice system. One does not replace the other. In all these cases, from the Beth Din to the ecclesiastical tribunals, the principle is the same. They are systems of internal governance for a voluntary community operating in the shadow of and subordinate to the law of the land.
Block 3. Law-Religion Intersection. So, we have Sharia councils handling religious divorces, Beth Din courts arbitrating business disputes, and Catholic tribunals investigating marriage annulments. On the surface, they seem like practical, community-focused institutions. Yet, the very idea of religious law, operating in a modern secular society, continues to generate immense anxiety. This is where we need to tackle the myths head-on, because the intersection of state law and religious law is a landscape filled with fear, and the best antidote to fear is clarity. The biggest myth, the one that underpins all the others, is the idea of a parallel legal system. This phrase conjures images of a rival power structure, a competing judiciary that seeks to supplant the authority of the state. As we've seen, this is a fundamental distortion. These are not parallel systems. They are subordinate systems. Their authority is derived from two sources: the voluntary consent of their participants and the legal space granted to them by the secular state itself, usually through laws governing arbitration and freedom of religion. They fill gaps that secular law doesn't or can't address, matters of ritual, personal conscience, and spiritual status. They are not competing with the state court in a trial for theft. They are providing a forum for a couple who wants their divorce to be recognized by their synagogue as well as by the city hall. Their power is soft, not hard. It is the power of community standing and spiritual legitimacy, not the power of bailiffs and prison sentences. This leads us to the next major fear, that these systems are inherently oppressive, particularly to women. This is a serious and complex concern that deserves to be addressed without flinching. There have been documented cases, particularly concerning certain Sharia councils and the Beth Din's process for granting a mahr, where women have been placed in vulnerable positions. A man might refuse to grant a religious divorce to exert control, or a council might issue a ruling on a financial settlement that is less favorable than what a woman would receive in a secular court. These are legitimate problems. However, it's crucial to understand the safeguards and the context. Firstly, access to secular justice is always an option. A woman who feels a religious panel is treating her unfairly can and should walk away and place her case entirely in the hands of the national legal system. The rulings of a religious body on matters like child custody or financial distribution are not legally enforceable if they contravene a secular court order. Secondly, many of these religious bodies are themselves reforming from within, often led by women who are advocating for more equitable and transparent processes. There is a growing movement for standardized best practices, for greater inclusion of female scholars and decision makers, and for a stronger emphasis on the rights of all participants. The narrative of the helpless, passive victim often ignores the agency of the many people, women included, who take advantage of these services. They may see them as more accessible, less adversarial, and more culturally sensitive than the state system. For them, it's not about rejecting secular law, but about supplementing it in a way that provides holistic resolution, addressing both their legal and spiritual needs. The debate should be about regulation and oversight, not abolition. Ultimately, the existence of these religious legal mechanisms is a testament to the complex reality of modern pluralistic societies. We live in a world where people hold multiple identities. A person can be a British citizen, a devout Muslim, and a member of their local community all at once. Forcing them to choose one identity over the other is a recipe for alienation. Religious courts, when operating properly and ethically within the bounds of secular law, provide a vital service. They allow individuals to navigate life's most difficult moments, divorce, disputes, death, in a way that is congruent with their deepest held beliefs and cultural values. They are a tool for preserving community cohesion and religious identity in a world that can often feel homogenizing. Banning them would not make them disappear. It would simply drive them underground, away from any potential for oversight, regulation, and reform, making vulnerable people even more so. The real path forward isn't to fear these institutions, but to understand them. It's to ensure they are transparent, consensual, and always, without exception, subordinate to the supreme law of the land, protecting the rights of every single citizen.